to Tom. We're just gonna do it.
Thanks to Tom, I have the gavel, but I assure you I don't need it. However, I appreciate the thought. Here we are on March 22nd, our third meeting in March, and we have full house and folks here to help us out and keep us on the straight and narrow. That was the call to order, and the first thing that we have always done, with one exception, is if we have an internal presentation, it's been first. But the first thing after that has always been community input, and community input is up right now. Mr. Russell? There's a sign-up sheet, and there's a microphone, and I think you brought your notes.
Hey, Charlie, when we put the big plaque up about who's on this commission, you're gonna be an asshole.
No. Citizen Russell.
Well, I'd swap places with you.
I watched your meeting last week, and you worked very hard. And I thank you for your time and your consideration of some of my ideas, and I have some ideas and thoughts. And I just got the draft amendment questions, but I mean, my first thought was campaign finance disclosure, and
Sorry.
all right.
I apologize, I didn't.
We know it's not your congressperson calling.
Sorry about that.
And I'm sure we're all aware of what happened up in Croydon, so it may be that you do not want to delegate campaign finance disclosures to the school board to do something. You may want to get it going a lot quicker. I brought the election laws, which I dug out a copy of, but the state election laws, but I passed in earlier City Amendment 136, which is what the City Council has, and just a few changes in that amendment would, by putting school board member as opposed to mayor and city councilor, things like that, that should be adopted. I also think that's a home run question. You start off with that as question number one. Everybody's going to love campaign finance reform disclosure coming in, and don't bury it. Put it on the top. Get people agreeing with you, going yes. You know, that's my point there. Tracy is right. The amendment revision provisions are too complex, and I told you my life story on that, and I think they're too complex to fix. And to the extent that attempt is made, one, a lot of energy, and two is, I think if the bottom line is that the people are taking away the opportunity to have a vote by petition, then that goes down the tubes. You're taking away the people's vote. That's what plays on the street. You let that stay the way it is. It's complicated, and I don't think any amount of work is going to make it any less complicated. So that's my thought on that. Discontinuing outdated language. I've seen, I don't know if it was the old city charter, but there were provisions in there. You know, do you need to do that? I mean, for the election in 2012, this shall occur. Well, gee, boom, put it in the bottom, put it in parentheses. It's outmoded. It's self-deleting. I mean, do you really need to go say we're going to take out all these things because it's too old? You know, so I mean, that's my thought on that. I guess you're going with disconnecting with the city on the stipend. I would suggest a second question where you set the salary at, or set the stipend at $2,500. Within the last week or so, we've heard about a potential $75 million bond for a middle school. I'm not sure, facing that, the school board is the one to correct 30 or 35 years of underpayment, and maybe that could be put on as a second question. Another charter commission, I'm not sure. I guess it was in there. We'll have one in 10 years after 2011 or 2012. Whether, I think I suggested earlier that after 8 years you have a vote. You say, in 8 years, or whatever the number is, 2029, there will be a vote to determine whether we elect another charter commission. And I said some of this before, that you all, those that were here and those that were served last time, thought you got it right, yet here we are trying to make it new and improved and even better than it was before. And what makes you think that in 8 years we can't do the same thing? Or maybe if the people don't want it. So I redid without enough copies, unfortunately, and I had passed in qualifications earlier. Rewritten for basically in the positive voice, and indicating that someone moving from District A to District B would stay on until the next election. And finally, I guess, Amendment 4, I asked this question last time, 2 weeks ago, I guess. What is it about this Concord system that the people of Concord can't can't elect a clerk and a district treasurer? I mean, I was standing there ready to be clerk, and then somebody come in, and I've always been told, Russell, you run for the school board, they'll come out of the walls and run against you because they don't want you on the school board. And that's what happened. I came out and I was all set to sign up to be clerk, and Mr. Taylor came in. So I didn't have my candidacy filed. So anyway, so that's all I have to say today. Thank you very much. I appreciate it. I know you saved the best for last, and I appreciate going first.
No, I just think that it's rude of us not to allow public comment early. And because it may influence what we do later on. And there are several reasons why it should be. And I just think that it's the polite thing to do. I still believe in thank you notes. I'm that old-fashioned. So there's nothing wrong with being old-fashioned and doing the thing that's right.
Well, I've also sat through some presentations from your very knowledgeable attorney and picked up the flyers. And so, you know, I also learned if I bring a crossword puzzle like I did for the first time today, I'll get put up first.
Okay, don't eat too much cake.
Thank you.
Is there anyone else? I see no one hiding around, okay? And so let's move to the next item on the agenda, the approval of minutes from the March 15 meeting. Is there a motion to approve those, or?
I move that we approve them.
All right, is there a second?
Second.
Second. Are there any errors, omissions, corrections that people have to offer that they'd like to bring in now?
There is one typo. Mr. O'Shaughnessy's name was misspelled, and I will correct that.
Oh, you've already taken care of it. Okay. I bet he did it on St. Patrick's Day.
Missing the out.
If there are none, then I'll call for a vote. Those in favor of approving the minutes will say aye, please.
Aye.
Those who are opposed would say no, please. There are no noes. Are there?
I'll abstain.
Would you rather abstain?
Yes, I'll abstain.
Oh, you're beating me to the punch.
Yeah.
All right. And Mrs. Kane is abstaining because she was absent that day and wasn't here to hear our great discussion.
Right.
Okay. Well, then, moving right along, I think at this point, we go right into the work session. With some of the information I got today, it sounds like we still have a lot of work to do. And incidentally, I plan to stop somewhere around 9:15 if we go that far, and I'm sure we will, to talk about the meeting schedule and also identify the number of public hearings and when they will be. So we need to make sure that we get that done and still try to stick to our timeline. But if I'm a little late, I won't worry about it because we were early last time. So with that said, Bill, you and Mr. O'Shaughnessy are up, and I don't care if you sit there or here or in the middle of the group.
This is perfect with the team.
Go do it.
So just on this part, we've had 2 meetings, the last 2 meetings. Jim was at the one before, and I missed that one. And you went through a draft with some changes to the charter, so you could see the markup. Last meeting, we did a similar thing and focused on a really important issue, which is how to deal with changes in residency from the school voting zone from the district, out of the district to another zone, and we've got draft language for that. But from the meeting that Jim was at, Jim and I were talking today quite a bit. Poor Jim suffered with me too much today, but we had a great time to work on this to try and get us closer to, after this meeting, to a sense of, the words that will allow Jim to go forward and put together a draft preliminary report. But the open issue that I understood from the meeting that I wasn't at, that Jim was at, was really about this 49B process. And Charlie has testified today, the way it worked is the current charter basically took the statute as it existed in 2010 and plugged it right into our charter. And that statute was messy. So messy in the fact that from the time we adopted that charter 10 years ago, 11 years ago, to today, the legislature substantially changed 49B. And I know Bill Glahn was asking, well, what's in that 49B? Because if we propose to get rid of what's in our charter and then reference the current statute, we darn well better have an idea about what's in the current statute. So if you've gotten a lot of paper, I promise you, I think it'll be useful. If you go to this one, which is a PowerPoint change, and Jim, if you can get one for Eileen. Nope. There we go. This one is a PowerPoint. Everybody have it in front of them? Mm-hmm. Oh, thank you.
Viewers to know who you are.
I'm Betty Holden.
Oh, I'm going to be younger. Oh, I'm so happy.
So what this document, which has 7 pages, including the title page, does, is it walks through the ways that the charter can change, all of them, under 49B. And I propose that we go through it page by page. I'll lead it through, and it'll show as well, this document, where the current charter in Concord School District is a little different in substance. And that should, when we get through it, I'll take the first lead, Jim will correct me where I'm misstated, and then we have a discussion just after this document about reactions of this commission. So
Bill, can I comment on that?
Yes.
Just on a quick look at this before the meeting, in the 5 minutes or whatever, it looks like what we are doing is amending the charter. Is that correct, or are we revising it?
We're amending the charter, we
So
believe.
if we're amending it, why do we want to spend time going through the pages of this PowerPoint that talk about establishing a new charter or revising a new charter?
And I think the right answer is because that's what 49B says, and it would be, in my view, short-sighted not to have the entire context examined by members of this commission. It doesn't take long. I promise
you on that.
I think I know that you will, and you will be wise. You will be wise to.
I think
don't
the
have my
other
Apple
the
Watch
other
on, so
reason
I
is
can't
because one of the amendments we're talking about making is changing the process for revising and establishing a new charter. So it's this like question within a question. Our amendment is to change the process, so we have to understand what's in 49B, what's in the charter, and what do we want to preserve, and like Charlie Russell said, can we do it? I mean, is it doable in a way that the voters will understand?
So to Bill's point, on the second page, there in 49B, current law, there are 3 ways that local municipal bodies change their charters. The first way they change is what we did last time, which is you establish a new charter. We're not going to talk much about that. The second way is we propose to revise the charter. And the third way is we propose to amend the charter. It seems like a lot of words, but that's the way the statute works. It establishes a difference between revisions to an existing charter and amendments to an existing charter. What's the difference? It's summarized here. In 2011, Jim will comment as well, it was basically the number. If you were doing a whole bunch of changes to your charter that had some more systematic impact on the way your governance system worked, that would be called a revision, and you'd go through a particular pathway. But if what you were doing was doing just a single section or a couple of single sections, that was called an amendment. In 2022, today, the law has gotten better in this. That you could tell the first definition was very vague. It was not sure, not clear. There was litigation on it. What's an amendment? What's a revision? In 2022, the current RSA 49B has made it much clearer. Revisions are very substantial. You can see, we're not talking about any of those, as Bill Glantz just said. And then everything else is an amendment. So what we've been talking about, the 5 things we've been talking about, don't constitute these fundamental changes to government systems, but rather amendments to the charter. On the next, let's go through quickly each of the 3 pathways. On page 3, establishing a new charter. 49B says there is no way to do that without having a charter commission. That's the first point I want to get out. There's no way to establish a new charter without having a charter commission. We did that 10 years ago. That typically, the charter commission can be started by the board, the school board, or the municipal body, or it can be started by a petition effort. And once, by either of those, if they decide to have a charter commission, and you then elect your charter commission, you follow the process in the statute. This is just a summary of what's in there. You have your charter commission. The charter commission then produces a preliminary report, like we're doing. There's hearings that have to be held. There's a state official review. There's a legal opinion. We haven't written all this down. And then you finally get to a final report to voters. And RSA 49B6 says that's a 3/5 affirmative vote of the voters. That's to get a new charter. Now, we already have a charter in Concord, but if we refer to 49B, this is in 49B, and I think it's important to have that in our mind. Let's get now to the Bill Glahn point. What really matters for us? Well, there's 2 things we can do to a charter. We can revise it, or we can seek to amend it. And in RSA 49B, 49B, these 2 paths have different aspects to them. And it's important, I think, to think about them for our discussion tonight. The first important answer is, and this is something Clint Cogswell's been asking from the beginning, there is no non-commission path to achieve a substantial revision to the charter, a complete reworking of a charter. You need a charter commission. You need to elect a charter commission. Just a quick peek forward, if you look at page 5 for amendments, in contrast, if you're just doing an amendment, there's a direct path to the ballot without a charter commission by the school board directly, looking at it, proposing it, and also by a petitioner committee. And so I just wanted to highlight, let's go back to revisions, and let's look at the revision requirements in 49B. If the board is going to seek to initiate a revision process, it will vote to have a charter commission established and elected. And that, there's nothing in the statute that says what kind of vote the board must have to get the charter commission. In our current charter, adopted 10 years ago, 11 years ago, we have a vote. And it is 2/3 of the members, not the quorum, but the members. And I wanted to just highlight that because this is one of the changes that exists. If we do a petition where voters come together, there's a whole process that's more complex than is on the page. But the key point is that for a petition to get going, you've got to have, the 49B says, a minimum, at least 20% of voters in the last election must sign the petition to get a charter commission on the ballot. And in small districts, you can't have less than 10. So that's the way it works. What do we have in our charter for revisions that we're seeking to elect a charter commission? 20% of voters in the last election, but not less than 1,000 voters. This, the charter commission last time said, was a better provision because our elections are held on every year. And in elections where it's a state election, statewide election, we have more people vote. And in the off-state elections, we have much fewer voters. So the 1,000 minimum to get, so if you really want to get a charter revision, you really want to make substantial changes to the Concord School District Charter, and it's going to be a revision, not an amendment. What you have to do is get a lot of your friends together, sign a petition, get that charter commission elected, and then we're in the same boat. The charter commission, if it gets elected by the voters, gets a preliminary report after doing what we've done, and you got the lawyer, the state official review, you do the whole thing, you go finally to the voters if you get that far. And the statute now requires a 3/5 affirmative votes of voters in order to achieve a revision. Why? A revision is more substantial. It's a bigger change, right? It's like changing your form of government. It's changing big parts of the system. It's a 3/5 affirmative vote. In the statute, and Clint will remember this from last time, Betty too, in our charter, the vote in that circumstance required is simply a majority vote. And the reason was, when we were here last time, the statute didn't require 3/5. The legislature's upped it a little bit for revisions. And so right now, a key question for us will be, if we refer to 49B, it will have an increased vote. Let me go to the
Bill, before you
Yes,
do
go
that,
ahead.
I assume that the red ink,
is what's in our charter.
and you're referring to sections of our
Yes.
current charter?
Yes.
I don't see a section 23, but maybe that's now been compressed with.
Yeah, you got,
red line.
it's in the,
Okay,
yeah,
got it.
exactly.
All right.
In the original.
Trust me.
Yeah. So now let's contrast to amendment of a charter. Let's say someone wants to make an amendment. Now we can have a direct pathway to the ballot without electing a charter commission. So the school board can get together and say, hey, we have a typo in the charter. I think we should change it. They hold an examination, they hold some hearings, there's requirements in the statute, and they say, let's vote. Under the statute, the vote for the board to put a proposed amendment on the ballot in the next election is not specified. So by default, that's probably a majority vote unless the local community does something different. Our current charter has this exact same structure in it, where for amendments, the school board can get an amendment proposal on the ballot directly without a charter commission. In a matter of fact, that's really the right, the straightforward way to do it. But we have a vote. 2/3 of members, like in the revision, in order to get an amendment moving towards the ballot without a charter commission. A petitioner committee can also get together and say, we should have an amendment on the ballot. Now, that doesn't require a charter commission in this particular. The direct to ballot path is that the petitioner committee, 15% of the voters in the last election, this is the statute, but not less than 10. Okay, that's the statute. We have in our current charter a direct pathway to the ballot through a petitioner group. But ours is the lesser of 20% or 2,000 voters, not less than 1,000. And that's in our charter. So what happened the last time, and I'm looking at Clint because he was very articulate and strong, I remember, on this issue. This shouldn't be easy. This should really attract the direct path to the ballot. Should have to require a lot of people to get together and make this happen. Once you get that on the ballot, it goes to the voters. And under current statute, there's no specific vote specified, so that probably is majority. But in our charter, it's 60% for an amendment to get done. Finally, under the current, under the law in New Hampshire, 49B, and under our charter, you can go through a charter commission. In other words, the Charter Commission can be established just like it was for a revision, for an amendment. So the board could say, this is beyond us. We should really establish a Charter Commission to look at the whole thing and just check it out. That can be done, but you gotta go through and elect one and boom, boom, boom. So there is, in the amendment process, there is an indirect path by the Charter Commission, but again, once you get, like our recommendation, if we make it, once you get to the voters, the vote required to approve an amendment is 60%, not majority. So if we look on the last 2 pages quickly, the summary, and then I'll ask Jim just to correct stuff that I may have said wrong, because it's always good to have 2 sets of ears here and eyes. Revisions, the school board vote to establish a charter commission is, our current charter is 2/3, and 49B, probably a majority vote. For the petition requirements, the current charter requires 20%, not less than 1,000. 49B requires 20%, but not less than 10. The voters at the election, the current charter requires a majority vote. 49B requires a 3/5 vote. So we're a little bit off kilter there, and that's a change since the last time. Amendments, it's summarized here. The school board vote to put directly on the ballot. Current charter requires 2/3 of members. 49B allows a majority vote. The petition effort directly to the ballot, current charter requires 20%, but not less, not less than 2,000. That's a, then that's probably the first one was, I guess that may be the mistake.
20% or 1,000.
In both cases. All right, 1,000, sorry about that. Very good. And then the voters at the election, current charter requires a 60% vote, 49B does not specify. So, after Jim comments, what I'd love to see, if we were to go to a change that says, we adopt 49B with the following exceptions. That's really what we've got as the process before us. And Jim, would you comment if I add supplement?
No, I mean, I think that's, we went through the process of of putting together that side-by-side document, which was a monster and isn't terribly easy to get through. But it's thorough, and I think you need to have that so you can understand where the charter is compared to the law. And there are a lot of places where, there are differences, and some of them are material and some of them are not. We went through the process of just really boiling it down to the real, like, material important parts. That's what this PowerPoint is. We took the PowerPoint a step further, and we sort of drafted more changes to the draft document. Bill's going to walk through that, I think. And we took kind of like a tentative shot at just articulating how we would phrase an amendment in as succinct a way as possible. And that's really where we are. I mean, it's kind of, you've got to get to the point where we're proposing language and out of the process of just kind of talking theoretically, then we can talk through language and then decide, is this the right direction or not? So that's really where we are. I think Bill described things pretty succinctly.
Madam Chair,
Yes,
At
sir.
this point, I think it would be worthwhile to have some reactions from the commission on members in terms of what their reactions are to this, knowing that in the back of our mind is the idea to get rid of all of that clumsy stuff that's in the charter now and have an amendment that would refer to the current statute with whatever exceptions or changes that this commission would like to have in there.
Reaction. Clint?
So you could do that. You could say, we want to proceed and 49B is going to be the procedures with, but you can make exceptions to 49B in there. That all has to go to the voter.
They did it in this draft.
Oh, they
If you
did?
look at the draft of where the 5 is,
Yeah.
they tried to do that.
49B,
great,
right? 49B.
Where the what is?
Where the big 5 is.
Okay.
In the draft,
okay.
that's where they think they said it with the changes.
Yeah, we haven't.
We didn't go through that document yet.
Yeah.
Clint, I think it's just important to know that 49B is a floor, not a ceiling. You can't go below it, you can go above it.
Yes, that's right, I remember that. Okay.
How many, how big physically is 49B as far as pages or whatever?
Jim, we,
Is it like paragraph? I know it's not.
I'm showing you, right?
Or is it?
It's 10 pages long, I guess, double-sided.
It's not something you want to just have it as a.
No, as a matter of fact, that's what it looks like in our
I mean, this is the law.
statute.
Yeah.
Right, okay.
I mean, it's not terribly long as statutes go, but it is longer than you would want to.
Yeah.
But it did attract our,
What we're doing is we're incorporating it by reference as it may be amended from time to time, so it's gonna be sort of alive in that way. Like it'll automatically change when the law changes, except for certain carve-outs we've tried to establish.
So what happens if 49B gets amended in a way that makes it like space to go from, I mean, not that they would, but 60% to 75%, now we're lower than the floor?
I don't know. I mean,
that hasn't
Well,
been done.
easy. You provide in the charter that the process is subject to 49B as it is revised from time to time. Right. That way, they can increase our requirements, but they can't decrease them. And if that occurred, then you'd have a process, then the voters in the town, well, as a practical matter, the voters in the town couldn't fix that one. They couldn't, so if they set a 75% requirement, then you couldn't have an amendment through this process to make it 60%.
Well, you have that situation right now.
Yeah.
With the revisions where you only require a majority vote, but 49B requires a 3/5 vote to adopt a revision. So the question is, well, what applies if you were putting forward a revision? And I think the 3/5 would have to apply, because I think that the standard I'm setting is, this is the floor, and we can increase the requirement, but we can't make it easier. I think that would go against the purpose of the legislature in adopting a higher standard, so.
But that wouldn't make our charter then section
No, and you-
void.
Right,
No.
good question.
Nope.
No, I don't think so.
Well, not if you put the language in as amended from time to time, right? If you just said our process is 49B currently, then you'd have a problem.
But Bill, I think the tricky part is they're saying 49B with these exceptions, so what if it's one of the exceptions that gets amended?
That's what I think what Tracy
Yeah,
was
so
asking.
that's what I'm asking,
So
and
they're
then there's
saying-
really, like, does that automatically trigger a charter commission to, or the school board to fix that, so that we're,
Subject to the following.
May I try?
There's no like savings clause.
No,
right?
let me try and answer. I think,
By,
The statute. So right now the statute says, a majority for basically, we're saying we want a higher standard here. So then what if the legislature then says, as in Tracy's hypothetical, 75?
why do we
We say
care?
60, which applies. I would think the 75 stays,
Yeah,
even
the
though this says
statute
60, yeah.
applies. We've made our charter subject to the statute.
well, I think, but when we set the number, here's what I think, all of this takes place from a fundamental purpose, which is in our Constitution, where the local government, municipal charter, has great power, and the legislature can't force a change on a local community under this section, Jim, of the Constitution that leads right up. And the problem is when the legislature makes a change, they think they can, but there would be a fight. So Tracy, in your case, if we said 60%, and the legislature then subsequently passed then the legislature went from 50% majority to like 80%. Let's assume they did. And the question would be, if Concord goes for a charter amendment and the voters vote, and they vote for 65% to approval, it doesn't pass under the statute, but under the charter, there would be a strong argument, I believe, that the legislature couldn't change the will of the local government voters expressed in the document. However, it's not, the answer that Jim gave, I think, is right, which is we don't really know how that comes out.
Yeah, I mean, there's not a robust bunch of case law to draw a bunch of analogies to, so we don't.
Lawsuit.
What if you said something like this, provided, however, notwithstanding anything in RSA 49B, the following provisions shall apply?
You can.
And then, but frankly, I'm not particularly concerned about instances in which the legislature makes it harder to amend the charter.
I agree.
I'm more concerned about instances in which they make it easier.
I agree with that, Bill.
I do too, and that's why I think that's the, I think there may be a there might be a however missing in this.
Yep.
In this intro, it says provided, it says just as provided, comma, subject to the following. We haven't worked that clause out, but that's what we're going for, is notwithstanding 49B, these are the, and that's a summary of it. So I'm not sure, how do we turn that into a ballot question? How do we do all that is down the road. We're not there yet, but this is the concept of.
I think it's an academic issue, but the greater concern is what if they just repeal RSA 49B, right? Which they probably
That would
not gonna
cause-
do. That would then create real chaos.
That would cause probably a charter commission process through a revision.
Let me ask a couple
I
of
mean,
questions.
that's a constitutional issue though.
Yeah, I agree with
So
you.
they
Same
authorize
question.
the legislature, so maybe the question, I haven't looked at this, but
Yeah, well,
is the legislature,
forget it.
that's
It's-
academic, it's not
like-
probably gonna happen.
It's like.
By the way, if they did that, every municipality in the state would be in trouble for the same thing.
It's a
So
law
they-
school question,
Yeah,
not
exactly.
for us here. I had a couple of questions about, first of all, notwithstanding the time it's spent, probably it was worthwhile going through this, but so if you amend by a petition or committee, it seems to me the problem with that is you gotta have somebody to draft the preliminary report. So I think that as a practical matter, when you're working with a petition, you gotta have a lawyer to help you draft the report. And that's gonna be the full employment for Mr. Ardinger in his retirement.
Yeah, right.
The,
This is my swan song.
The other question I had is this, and it doesn't really, I don't think it affects us terribly, but why would you ever try to do something indirectly under the amendment process that it's easier to do directly?
I'd like Jim to answer that, because he said, so why would you go through a charter commission, the indirect route, when you can do it directly with the board?
And with lesser requirements.
I think that's why the legislature doesn't not involve a charter commission in the amendment process at all. It's not even contemplated in the current law. So if Concord wanted that, it would be because Concord, I think, felt that if you're going to do this process that we're going through, it's complicated, it's time consuming. We would want the voters to weigh in on who would be involved in that process and to put forward like a really well thought out amendment. Otherwise, you have a board sort of, so we talked about a board forming just an ad hoc subcommittee and studying it as three members of the Concord School Board, and then bringing a recommendation to the school board voting on that amendment and putting it forward. That could happen too. But it's.
For example, one possible reason might be that the school board decides, we want to amend this, but you know what, we really think a charter commission should be formed. And so then they adopt the process that essentially adopt the revision process because that's the indirect route.
That's what we're doing right now.
Yep.
The only reason we're here is because the charter created this group. And the only reason we're following this robust process is because the charter directs you into the revision process. Even though we're not talking about revisions, we're talking about amendments. And it took me a while to understand how we got here, because we're only talking about revisions. But it's complicated. And for a board to try to tackle that and not put it before a commission also can, that people might think, well, what's the board's interest? Is this political? Is this, that way you kind of have a neutral commission studying it and not involving the
Did
government.
you just say because we're only talking about revisions?
I think you accidentally said that.
Oh,
Yeah.
because
Yeah,
we're
we're
only
actually
talking about amendments.
right.
Yeah.
Yeah.
But it just seems to me that amendments can be just as complicated as revisions in the way we used to think about revisions. Now, a revision it's a very, very narrow set of decisions that very few communities will go through the revision process because that's a total change. An amendment is everything else. So I don't know. I don't know if this will stick. I can see the legislature down the road creating a third pathway to amendment through the formation of a charter commission as an option. It doesn't currently exist in the statute. But I think the charter itself could create that as well, and that's one of the things we've written into our three sort of proposals.
Well, it does do that. It just requires that you follow the process. It's kind of a backward way of doing it. If you want a charter commission under an amendment, you have to follow the revision procedure.
Well, that right, really, the Charter Commission, and this is Betty Hoadley I talked to about this, who brought this point up. The Charter Commission pathway has 2 votes of the public. One to elect the Charter Commission, and then one to review what the Charter Commission recommends. That's costly. In fact, when you think of some of the testimony we had, like Charlie Russell tonight, his testimony, he said, don't take away the petition, the direct petition route. I don't think anyone has proposed that. And this presentation, as a matter of fact, what this presentation I think should highlight is exactly what Bill is saying. That really, who sits in the catbird seat on making sure this charter is doing the right function for the school district is the school board. Mm-hmm. They may not understand that they have this tool available to them. And one of the reasons they may not understand it is that our charter from 10 years ago took away the need for them to understand it. Why? Because there was going to be this double election, costly process in 10 years. And we've talked about that in this thing. So I think one of the reasons it was good for me to personally to go through this exercise today is it made clear that there are really efficient paths to make sure the charter document stays functional for our district. And the best paths are the ones that the school board. Now, if we have a rotten school board, what's also clear is that there's a petition process that can get going with active, and that's also very clear. So to Mr. Attorney Russell's point, don't worry. I don't think anyone on this commission has talked about removing a petition pathway. We are actually supporting that.
Isn't the simple, for the public, the simple explanation is what this charter will provide is a pathway from the school board, a pathway by petition, and a pathway through charter commission. The only difference is that in the current system, you had an automatic charter commission 10 years later, and we're eliminating that.
I think that's, what do you think? I think that's pretty good.
Yeah.
Well, I had a concern about the Concord School Board suggesting an amendment, and I worried about the number 6. And I even talked with Bill about the number of 7 out of 9. And someone might say, well, that's a pretty high bar. Yes, it is. But it's a bar that they already pass. If you remember when Jack Dunn, the finance guy, was here, and he talked about the second passing of the budget. The first passage is just a majority vote. But the second and final passage is 7 members. And he said, we welcome that standard. And that, I think he was saying, that's the price of autonomy, maybe. But here I am throwing another horseshoe out into the pit when we're talking about something else. But there's more to the possibilities than just what's there, and I agree with you. I don't think the Concord School Board ever realized that they had it, and they didn't need to, because it was already settled.
Well, and if somebody suggested you had a crazy school board, whatever they come up with still has to be submitted to the voters.
To the voters.
Right, well, and in the last analysis, the vote will determine whether it
And
was
they
a
had
good
to get
decision or
60%.
not.
Exactly
Of the
right.
voters.
That's
a great
huge.
trail safe, because you don't know what kind of school board you're gonna have in 5 years.
Exactly.
And you can't, it would be way too scary to leave it in the hands of,
Yep.
Those of us who sat on the school board in the past say, there have been past crazy school boards. We were on it.
No, but these are
Maybe
different
like Croydon.
times, and unusual things can happen. And I could see how, maybe I'm a fearmonger, but I could see how you might have as many as 6 anti-education people on the school board, and the safety of having that 7th, I think, would make me sleep better at night. However, I'm not gonna follow my sword over this, I'm just putting it out as an idea.
Well, I think too, you don't draft charters for crazy situations. You draft them to protect the charter, but, we could think of all sorts of parades of horribles that we wanted to try to cover. But it's done pretty well so far, and 60%, if you could get, for the most part, you can't get 60% of the voters to agree on what day of the week it is. So, unless you're having elections in Russia, so.
I think that's what Tracy said. I think what we end up coming together to do is build a balanced system, because you can't predict the future. And the ultimate test is a democracy test. It has to pass the gauntlet with the voters, and setting that higher amount, that 60% amount is something that puts a real test. And hopefully, the democracy process then would initiate a lot of energy in the community. Community would become more involved, would focus on what the issue is, focus on their school system, and maybe get a better result. So I think we can't predict which way the board is gonna be in the future. We have to build really objectively balanced rules.
Okay, Bill, can I ask a question? And I know you're gonna get to this, but is this document called draft amendments for consideration? The numbering system on here, I take it, corresponds to the color coding that you had on the last document?
Actually, there's 2 documents that are before you. Jim and I were working hard today, and I said, the real hard thing you're gonna have to do, Jim, is draft the amendments and the explanations for the preliminary report. And Jim went, yeah, I know, we gotta get that done.
No, I said, that sounds like fun, I can't
Well,
wait.
And then what happened was, Bill, I drafted that afterwards.
Yeah, he
So
couldn't
I went,
contain himself.
I took a shot, so it corresponds to this other document,
Okay.
amendment 1, but those are basically consistent.
All right, so let me ask this question, probably for efficiency. Are there changes in the language from your prior draft, which was color-coded,
Yeah,
to this draft
yes,
that we ought to discuss?
couple of
And we
very
will-
minor
we will
ones.
dis-
Yeah, so I
discuss-
don't think you need to go through all of them, because our job for this was to look back at that, but I think we want to know where the changes are from
But
the
should we
past
finish the
document.
issue of
Yes.
60% or of 6 or 7 before we move on to the rest of the things?
Well, what authority do we have to tell the school board on the budget process?
No, we're not talking about the budget
No,
process,
no,
we're
no.
talking about here, so
Okay,
in
so-
number 5 in the
Yeah,
in
so
the
I
draft.
think what Kate's saying is that we ought to look at how we boiled everything down from this talk of 49B into hopefully a concise way of articulating we definitely need to talk through and look at that, so.
And can I,
Betty's saying it should be
So Betty wants a
7/9 or whatever.
real super.
there's a good way of talking, but I want to address one issue that came up. Eric, I checked while we were discussing here, in our current charter, at 21, which is for charter amendments, 21, Roman 2, it's the petition. It actually reads 20% of the number of voters casting ballots in the last regular school district election, or 2,000 voters, but in no case fewer than 1,000. So it is that, and I think what's good about raising it is that there's a disconnect between the revision petition and the amendment provision. I think there's a reason for that, but just hold that thought, because now to Kate's point, what we'd like to do is if you could take the document that says draft amendment, this is the markup, and we'll do exactly what Bill says later. If you would go to the big number 5, you'll find the 5 in there on the top. And that's, these are not numbered pages, but it says page 6 of 14.
It starts on page 5, though.
Yeah, but it starts on page 5, exactly right. So if you look at this, which is now the new section 18, and I think it's worthwhile just to read it, because it's just handed out tonight. The charter shall be subject to revision or amendment in accordance with the provisions of RSA Chapter 49B, as such statute may be amended from time to time, semicolon, provided, subject to the following. So these are the 3 exceptions. And the exception
Bill likes
is-
it. Bill Gahn likes it.
The drama of the semicolon.
This is like the people who put the PowerPoint slide up and then read it to you.
Well, you
No,
got it, because I think that the language is particular. So, the first one is,
Keep in mind, our viewers can't read it.
And keep in mind, Bill and I did this all day. Like Bill,
Can you-
this was my day, basically.
Sorry.
Just pretend you're a Shakespearean actor and let's go.
True, the viewers can't see this, so you're
to
doing it for
be,
them.
No,
or
I appreciate
not to
it.
be.
If you close your eyes, it just flows.
So if you go, here it says, the first exception is that at least a 2/3 majority of the full number of school board membership, that's 6, shall be required either to submit a charter amendment directly to the voters or to establish a charter commission. So this first one raises directly Betty's issue, which, as Kate said, we should talk about and pin down. Because Betty said, I don't think the school board should be able to get an amendment directly on the ballot with just 6 of 9. They should have 7 of 9. Now, some of you might say it should be a majority of a quorum, but I think we gotta nail that issue, because this is an exception to 49B. Any responses to Betty's, discussion
I
start?
want to get through your dramatic reading first, then let's go
Okay,
back.
okay. Number 2, that a written petition of at least the lesser of 20% of the number of votes, or 2,000 voters, but in no case fewer than 2,000 voters, we gotta get this right, shall be required for a petition or to propose a charter. So this is saying, let's try and get this to something that makes sense for Concord. And the idea is 2,000 voters, in no case fewer than 2,000 voters, and that's because we have such a variation in our cycle. And the
Then-
final one, to Bill's point, is that when you finally get it on the ballot, that at least a 3/5 majority, 60% is required to pass it. I think 3, I haven't heard any objections around this table, but 1 and 2 have gotta be hammered out and talked about here.
So Bill, what happens, so this process applies to, yeah, it's okay, I got it. It's gotta be strong enough so it covers both revisions and amendments, because it has to be equal to the revision requirement, because we're adding the language about revisions as well as amendments. If you wanna revise the charter or amend it, so whatever process we have, for petition, for example, it has to be at least 20%, because that's the standard for revisions. It's a higher standard than for amendments. Does that make sense?
Yep.
So
So-
one of the questions that we need to decide, you're saying, is whether we want well, 6 or 7.
Right.
I don't know what 2/3 is 6, so what's 7?
Just write 7 or 9.
7 of 9.
Yeah. 77. And as I think about it, having served briefly on the school board, getting to 6 is pretty easy. Getting to 7's hard. And that may be wise, because this is a big deal. Having something go directly to, right? I mean, that's what this is saying, is that either to do an amendment or to consider a new charter or charter commission or amendment or revision or anything. I'd be interested in hearing people's thoughts about making it 7 versus 6.
I'm not gonna say any more. At home,
Yeah, I
they call
know.
me
We-
at home, they call me the general.
Yeah.
So,
Not
know where
just
you
at
stand.
home, Betty.
If you've been on the school board with Betty, you should get that. You know, I don't feel strongly about it one way or the other. I think that you've got a supermajority vote protected by a 60% vote at the other end. And I get the fact that, well, and maybe you're gonna have a harder time getting 6 votes on a school board to amend the charter. But if others think 7 is the right number, I have no problem with it. It's you know, you want amendments to the charter to be difficult.
Right.
But I feel like there are very few situations, say with boards of directors of corporations or nonprofits, that require more than the supermajority vote of 2/3.
Mhm.
It seems like you either go to 2/3 or you go to unanimity. But
We talked about that, and we talked about the difference between two-thirds of just the members present and voting versus 2/3 of the full membership. So we thought 2/3 of the full membership makes the most sense.
Of the
We talked,
membership.
Yeah.
we talked about the issue of vacancies and what if there was a vacant position that hadn't been filled. You still need 6 if it's one vacant position to get 2/3. We kind of talked about 2 vacancies. We're getting into the weeds a little further, hence Bill's addition of that parenthetical without regard to vacancies. It's a pretty high, I mean, that's about as high as you get without going to like unanimous vote, basically.
2/3, you think
I
is.
mean, you don't often see it, but I don't think it's impossible to say
Right,
7.
I guess what I think about is Betty reminded me of when we voted on the budget, that we went up to 7. I mean, it was like, this is a big deal. We need to really set the bar high. And it felt like it was a really, an important decision to make.
I could be wrong here, but I think the vote on the budget is actually majority vote, but the vote to change the budget in October is the higher number.
I think you're right, I think it
You're right.
is.
once you go beyond the March 30th.
the majority vote is the March or April vote, the tentative budget.
Right,
The
right.
7 vote is the final
The
budget.
final budget. Right, Tom?
I'm not gonna,
Yeah,
No,
that's
I
right.
am
I'm
gonna
sure
fight
that's
over
right.
that one.
No,
Yeah.
Lyndon's right. If we pass a budget, if in June we're gonna change it, you need 7 votes. If you pass it just the way it was presented, then
can
you
leave it
need a
at 6.
majority. And then in October, we gotta repass it again.
That's
and
the one
that
I'm
needs-
talking about.
That needs 7 votes.
that's the one I'm talking about.
Yeah, okay.
Yeah.
The other option I just thought of, because there's all kinds of ways to make it tighter, is you could say you must have a vote from each, affirmative vote from a member from each zone, or we still call them, that makes it, I mean, you could do that.
That to me goes against our instincts of
Oh.
people aren't members from zones. So, but let me offer another alternative, and then I think and then it'll bring it into sharp focus, which, another way to skin this cat is to say 2/3 of the board and 2/3 of the voters. So which is it you're really protecting against? Are you protecting against for a pejorative term, a rogue school board, which still has the protection of 60% at the other end, or are you protecting against, are you creating a supermajority in essence of the voters, right? So,
Could you ever get 66% of the voters to vote on anything?
Can I throw something out there for a sec?
Yeah.
On that? When you're talking about 60%, if you just look at the numbers, 60% or 7% or 6 or 50% isn't a big number. 2011, 3,713 people voted. 2013, 4,173. Somebody's handwriting is terrible. 2015, 4,365. I'll skip to the biggie. 5,104 in 2019. Nobody votes. So if you're looking at 60%, that 10% is just a couple hundred votes.
But you're picking if it were in an odd year.
No,
If it's in an even year, those numbers are very different.
yeah, but even in odd years, trying to get 60% of the voters to go in, even if you've got 10 voters, trying to get 60%, well, 10
It's
is
only one
probably
vote.
an absurd number, because then
Yeah.
you're only talking about one vote swing. But if you got 1,000 voters, that's a 100-vote swing out of that. That's 10% swing. That's hard.
To put it into context, sorry, I don't mean to interrupt, but to put it into context, the legislature changed the bond vote requirement from 2/3 to 3/5. It used to be 2/3. It's very, very hard to get 2/3. 3/5 is difficult, but obviously more attainable. I'm not sure that's helpful at all, but for a frame of reference anyway.
Tom?
To me, it's sort of about conviction for the school board. If there's a 6 out of 9 versus a 7 out of 9, for 7 out of 9, you've got real conviction. You've got real, let's go forward with this. And if you got 7 people who are in favor, you're very likely going to get unanimous voting. If you have 6, you're going to show the public, if the procedure gets to the vote, you're gonna get folks feeling like, well, this was only 6 out of 9 of the school board members, and what were they thinking? If they really wanna do it, it should either be 7 out of 9 or unanimous, 8 out of 9.
But, I mean,
It's my part.
I see that, but then what if you have a smaller group of people that comes up with an issue? Let's say the demographics totally change and they wanna change the zones or the wards. And you've got a school board that doesn't match your population. Now you've got to get 7 people to agree to do it. Where if it's 6, yeah, the voters would see that, but maybe that represents more what's going on. I don't know, I can just see a lot of ways where it still has to go by 60% of the voters.
Except that if
And maybe we don't want our school board 100% agreeing on everything. Like, some dissent is a good thing.
But if people think the school board's being obstructionist, they can create a petition.
Right.
Well, then the
So,
other
Tom,
thing,
look, as I said,
You don't really care.
if we just take a vote at 6 or 7, it doesn't, I think it's 6 of one, half dozen of the other.
Well, I mean, does anyone feel like it could be prohibited beyond your scenario that you just gave? If 7 is prohibitive, then we should watch it, but I've heard a common thread throughout our weeks of discussion about making this difficult, making this purposeful, and making this, very direct.
demanding.
And so 7 does that in its very small way, but it does that.
It's interesting, it's starting out with Nancy's first comment, that Coletti's suggestion. If there were a change that needed to be made because, oh my God, the bond lawyers say there's just a weird word in there and you've got to be updated for tax-exempt bonds, you're going to get 9 of 9.
Yep.
To go directly and bypass the other path, which is the double public vote on the charter commission. But if you're starting to play games with a more controversial issue, that number 7 or 6 is really determining whether you're able to go directly to the ballot or whether you're gonna get 2 public votes and a charter commission process. So to me, you know, I guess I'm a little bit like Bill with the eggs, but I think I could easily support 7.
And you know what? We should take a vote just to give Betty for once what she wants.
Can I just bring up
I'm
two?
too old to
A
worry about it.
caution.
No, well, 2 things that we'll want to think about is, one, when we're talking about the vote of the board to submit a question to put it on the ballot, it's a fallacy. There's going to be many votes in the process. And so I think you have to word it so that like any vote, right? So there's gonna be the vote to initiate it, then there's gonna be a vote to, like, we're going through all these like other votes to, is this the language we like? And then there'll be a final version after public hearings, and there'll be a vote to order that to be placed on the ballot. So there's a couple of votes that are happening, and so we're envisioning one, and there's maybe more, and I don't wanna be too, persnickety, but I just think it's not as simple as you think. The other thing we talked about, I'm just throwing options out there, Bill may not love it, but we talked also about creating a different standard for the board to go directly to the ballot versus the board to go through a commission. So right now, this is 2/3 for either, and I'm not sure where you are on that, but if you would rather it went through a commission process, you could make that a 3/5. Or you could make that 2/3 and you could make the board direct, the 7/9. So there's a lot of different ways, and all of them make it more complicated and
Yes,
start making your
exactly.
head
Spin.
kind of spinny.
I wonder if you didn't just bolster the 7 out of 9 argument by talking about the very difficult and lengthy process. And if it's going to be that, which it is going to be, then it ought to be truly a 7 out of 9. I mean, there ought to be 7 people on that board who are saying, we really ought to do this and pursue this very lengthy and difficult and maybe costly process to get there, rather than 6 out of 9. I mean, we may be just beating a dead horse here at this point, I'm not sure.
To
but-
Jim's point, though, which is, if you're gonna go the charter commission route, you get 6 to start that, but then people have to be elected to the commission. And the irony of that is, we're sitting around here, there's no process for how many members of the charter commission have to vote to put something on the ballot. This could be, 5, it can be just simple majority. I mean, I think we started out in this process saying, we probably want some consensus, if it's a real close vote, but I'd be inclined.
We're not going
I kind of like Jim's idea. Yeah, we're not going to know. I kind of like Jim's idea of, if the board wants to do it directly, they really have to get the votes. If they want to do it indirectly, 2/3. Now that just requires some more drafting. That's all.
It's not hard, it'd be another little A, B, C, D.
Semicolon.
Yeah,
Yeah.
I'll do it.
Just tell Bill.
So can we move this question?
Yes, go ahead,
Yeah.
make a motion.
So I make a motion that we increase the required vote where the school board would make an amendment direct to the ballot from 2/3 to 7.
I'll second that.
Everything else remains the same.
Is there a second to that motion? All right. Then we'll go ahead, do we need to discuss it anymore? I thought we were trying to bring it to closure. Okay, then, do we want a roll call vote? or
Just clarifying question, you're talking about all else remains the same, you're talking about with this here. Okay,
Yes.
not,
Talking about altering.
yeah, okay, just that
Just
paragraph.
this one, yeah.
Exactly.
Okay, thank you.
Does anyone want to call for a roll call vote? If not, I'll take a voice vote. All right, those in favor of the motion as presented, will say aye, please.
Aye.
Those opposed? There are none. Abstentions? There are none. It's a unanimous vote. 7 for one process, 6 for the other. Thank you.
That's good.
semicolon that Carrie did.
Yeah, and put in the semicolon in the right place.
Don't increase your rate for semicolons, that's the important part here.
Only if Bill reads it at the next meeting.
I shall read it. Thespian. The next issue is.
I turned down my hearing aid.
I wish I had
Very
that.
loud. Number 2, there is this issue that Eric identified,
Which is incorrect.
no, but
No,
this
you're the
draft
master petition.
before you is now incorrect because of, so the question is, given Eric's, the low vote, let's just assume the low election vote is, let's say, 4,000. The high election vote is 10,000. 20% of 10,000 is 2,000 voters for a petition. 20% of 4,000 is 800 voters. So what I would like to have from this group is what should our petition requirement be? Tracy?
So I've been sitting here doing math. So I have a little issue with 20% of the, okay,
I doubt this.
you know what, I just answered my own question because I did the math. Never mind. I always thought it was meant registered voters, and I was like, you could never get
No, it's
20%
the people
of
who
registered
No,
voters.
voters in the last election.
Yeah.
And the
Even
other
so,
thing we have to
2085.
remember is that
was
there's
my
a,
point, was-
the other thing we have to remember is there's considerable differences in the number of voters depending on what year it is. A
Yes, of
midterm
course.
election and a national state election. And so I'm just saying that we do have different numbers of voters show up in certain years. And I don't know, well, I think it's clear that we always get more in midterm and in national elections. So probably we want to think of it, well, both the high and the low numbers. Go ahead.
Actually, my math was right, I was just thinking of it wrong. So 2,000 people is 8.46% of Concord's registered voters right now. So you're saying that if in order to change the vote, you've got to get 8.6% of people to sign a petition, because there's 23,976 registered voters, according to the Secretary of State. I just looked up. But anyway, that's more people than come to vote sometimes in elections.
But that's not the standard, it's voters, it's the voters in the last election.
Yeah.
Right, I
But
know,
there's
I know
a
it's
minimum of
standard.
2,000 still.
So
According-
2,000 people is sometimes more than would actually vote in an election. You're saying that they'd have to, so if there's a group of voters who maybe wanted to change the wards or the zones or something, or there was something that came up, you're talking 2,000 is a high bar. Can you get 2,000 people in Concord to sign, I mean, can you get 2,000 people in Concord to buy Girl Scout cookies? I'm not sure.
Well, that suggests, I think,
It depends on who you have leading the charge.
doesn't that suggest that we ought to follow the procedures of the statute, which is, I think this is right.
Not less than 1,000, right?
I was gonna say, Tracy, the statute is 20% for revision by petition, which gets you to a charter commission, and 15% of voters in the last election to go directly to the,
And I don't mind the percentage
Yeah.
based on the last voters, it's that 2,000, that no fewer than 2,000. I think that's too high of a threshold based on the number of people who vote, and that's over 8% of the actual registered voters in town.
I'll give another, just a frame of reference, because this is what I do. In cooperative school districts, if there's going to be a petition to hold a special meeting, it requires 5% of the voters. It's sort of, that's like the same kind of thing. You really have to get people motivated to sign a petition, and that is generally seen as a relatively hard threshold to get over.
And that's about 1,200.
So you might, I mean, right now it's, so you could do 20, but, figure out what 5 or 10% is and then say that's, so right now it says a lesser of 20 or 2,000, but no case less than 1,000.
so
Right,
watch
no, it
watch
says
this.
2,000
Watch
still.
this, yeah,
In
I
this,
think
in this
that was an
document, the
error,
current
right?
charter.
that's an error. It
Yeah,
should be
it-
1,000.
Okay.
Let me
Okay.
do this math. If I want to get a petition and get something on the ballot, what I'm going to do is say, when do I start? I'm not going to start after the big state election, because then the number's 2,000. I'm gonna start after the small election where it's 800. So Tracy, we're dealing with that flow where,
Right.
in fact,
But then you're gonna have to get 1,000 voters.
well, that would be the minimum, would be 1,000. And I would support, me personally, notwithstanding my stupid typo, would be 20%, but not less than 1,000.
So that's what I was getting, 1,000 seems okay.
Right.
2,000 seems
high.
totally like a
Right.
barrier
But
saying you don't want
a
change.
thousand seems, I mean, I feel like, again, back to the mantra of this can't be too easy. I mean, I think it needs to be, but it has to be reasonable. I understand that. But 1,000, I mean, if you've got a burning issue, you
You're
should,
gonna get it.
well, you need to be able to get 1,000 people.
Yeah, but look at the numbers that, well, by the way, I'm fine with 1,000, we should do that, but you still got it, the 1,000 only comes into play when the 20%.
Is it-
can't-
is
you gotta
it
start
met?
with- You start with 20%.
Right.
And as a practical matter, I really thought Eric's point went to the other end, which is, don't make it impossible for somebody to have a petition.
Right.
But make it really hard for that
That's-
to get elected. But I also think 60% is.
But I'll tell you, it's easier to sign a petition with your name and your street address than it is to go and vote.
Sure, but you gotta get somebody to go out there and find those people.
Well, that's what I said
And
before.
my
It depends on
inclination
who
when
leads the
somebody wants me to
charge.
sign a petition.
You just sign it.
No. if I
Karl
don't have a
Marx?
lot-
It's still,
It depends on what it involves.
Social media has made it.
But generally.
Yeah, I was just gonna say that social media has made it significantly easier.
But do those count? Like if someone's filling in a petition with their name and address and making it up on? or
I don't
would
know
have
why
to
it
be-
wouldn't.
No, it doesn't count on our charter
The
because
petition has to be.
it's a
checked.
very
It has to
strict
be
procedure you have to
Right.
go
So
through.
it's
Because
still
you have to
1,000
compare
people.
signatures.
Yeah. So-
We got a lot left to do, so let's just pick 1,000. I don't think it's.
Yeah,
I'm
I don't
good.
think anybody's disagreeing with
Fix your
1,000.
typo, Mr. Edinger.
Well, and
But
better
typos
yet,
are
we
What
don't.
trouble that costs.
Yeah, we can just mimic what's currently there and say, you
Yeah.
know, 20%
Then the question is,
or 1,000.
20%.
The lesser of 20%
or
or-
1,000.
Okay,
I would make that motion,
Minimum.
Second it.
minimum of
Minimum
1,000.
of 1,000.
Yeah.
You're just fixing the
20%
typo.
would get you 800 if it's.
Right. So a minimum of 1,000, it's
Yeah.
20%.
oh, good point.
The lesser of 20% of the last, or 1,000.
But
No.
not, that's the way.
Not
it
the
reads
lesser.
No,
No, you just gotta change the 2,000 to 1,000.
With,
Your language is fine except for the number.
okay,
and
gotcha.
a semicolon.
okay.
Got it.
Are you ready to
Yeah.
make the motion?
I make that
There-
motion.
there's two
Second.
seconds in two places. They're changing both.
There's a motion and a second.
They're changing both places. Thank you.
Okay. Do we have everybody all set on the idea? Okay. Those in favor would say aye, please.
Aye.
Those
Can you,
opposed?
can you restate the motion for Dawn?
Yes, the motion is, on the document we were looking at, to have it be the lesser of 20% of the number of voters, yes, Kate, I'm reading it, or 2,000 voters, but in no case fewer than 1,000 voters.
Which is pretty much what it says there.
You're
Yeah.
only changing it in one place.
Yeah, I'm only changing the 2,000 to 1,000.
Okay.
The second.
I actually think the
Well, excuse me, maybe.
No, go ahead.
Yeah, but I want to finish the motion.
Okay, finish.
the
Okay.
motion, yeah, sorry.
All right, please.
But that's
All
what the
right,
statute says, so.
I'll start back at the beginning to make sure that everybody's saying yes when they want to. You've heard the motion and you've heard the second, and it's also been restated in order that the notes reflect the proper procedure. Those in favor will say aye, please.
Aye.
Those opposed? There are none. Are there any abstentions? The motion is passed. I hope this isn't going to change my vote.
No, I'm clear, and this is one of the spots where I think the charter, those two were supposed to be the same somehow in the process.
Yes, I think they're supposed to be the same.
But it got somehow.
Yeah.
I think where we
Okay.
started this was, I asked, where is this document different from the
Yes,
prior document?
believe it or not, we're right there right now.
We just,
Hard to imagine.
By the way, going back to number one, which we already passed, it does something indirectly that we talked about last meeting, which was it'll clearly authorize the board to establish a charter commission for the purposes of considering amendments. which isn't specifically addressed in the statute, but will be part of the charter process. We had a whole that was kind of the whole conversation last time. That's incorporated in here. It's by reference, but it says it right in the last part of 1, and I didn't point that out.
But the statute allows that.
I don't think it's a problem. I think you can do more process if you want to go through more process. Okay. We're to number 3.
Okay.
Okay.
Bill, would you like to read that, or?
Which number 3 are we talking about?
Yes,
Number 5, 3.
3, well, I think 3, so let's look at
Oh, I
that
thought we were done with
on page, that 1, 2, 3. 3 is the
We're good.
3/5, 60%. I think everyone's okay
Yes.
with that. So we
Yeah.
don't have to have a motion on that. That's all set. Or I'll make a motion, that we adopt it as drafted here, as the 3/5, 60% for the final public vote.
Second,
Yes.
second.
Do you have an extra one of those?
Yes.
And then operating blind. You want you want this one, Martha.
Okay.
Thank you. I got it. No, I'm good.
So we're good with those 3 49B items.
Do we have to vote on that?
Yeah, so we've had a motion and a second.
Okay. Motion and a second. Oh, we're then dying as we speak, as long as we're not.
reading.
Right, as long as we're not. We have a motion and a second. All those in favor would say aye, please. Aye. Are there any nays? There are none. Any abstentions? There are none. The motion passes as identified.
With that, Madam Chair, we get to Bill's question. Where are the other changes in this longer markup? And I'd like to just point to them very quickly, because they're not going to surprise. And Jim, you're going to correct it. We changed one "and" to "or."
Wait.
Where are we? Which document are you on?
Oh, so let me, I'll jump in. So,
Okay.
If you turn to page, I didn't highlight it, so.
Oh, let me,
So it's on page 3, there's the 4. We had a conversation about whether it should be an "and" or an "or." It says the powers and duties of these officers shall be those prescribed by state law, by this charter, and by board resolution. I think that, it wasn't "or," I don't think that was the
Yeah,
right
it
word.
should be an and.
yep.
So that's simple. The other languages and qualifications, this is, Bill, this is your
Let me go-
tweak. Yeah,
go
so
through it.
you're up now.
So down in that section 5, you come down to the second to the last sentence, beginning whenever a school voting zone member ceases to be domiciled. This is what we agreed on last meeting, and this is my attempt to reflect it.
So I have a question about this section, which
Yes.
may or may not bear on this. We start out by saying to be qualified for election to an at-large office of the board, the candidate has to be a registered voter in the district. Then we say to be qualified for election to a school voting zone, the candidate must be domiciled in that zone.
They should probably also be a registered voter, right?
Shouldn't it say,
It should be the same
Well-
language, is what you're saying.
yeah, mirror it either way, because I think in order to be a registered voter, you need
Have
to
to
be
be domiciled.
domiciled. But I would say,
Is it required now that you have to be a registered voter?
Yes.
Really? I mean, I've always been, so I never thought about it.
well,
I just thought you
that's an
had to
interesting
reside
question,
in that.
Nancy.
It's
Could you-
100%
could You
required.
put your name on the ballot for,
No,
so
I
this
think
is
you-
talking about qualifying for an election.
But I
When you
think
go,
it's
when you go into the school board office, clerk's office,
Yep.
to register to vote, could you sign up to run for the school board even though you're not a voter and then register on the day of the election? But
I don't
The answer
know.
is no, and I've dealt with the Secretary of State's office
Okay,
on this.
Okay.
that's good. As
So
long
you
as,
have to be a registered voter at the
I
time the
think it
filing
just-
period starts, and you can't register during the filing period.
so the language should just
It should
say that in
it-
both
I think, yeah, I
sections.
think it should just say that to register
I
To
used
be
it,
qualified for election for a school voting zone office of the board, the candidate must be a registered voter in the district and domiciled in the school
yeah.
voting zone.
But I think we have to be cautious about the word domicile. Do you remember from Board of Trustees, all the issues about domiciles?
Oh.
And when people get tuition breaks because of, and who's domiciled and who
Can you just
lives
say
in-
reside in this,
Yes,
reside in
I'm
the school
saying-
voting
I
zone?
think Kate's
Use
situation
a
solves
generic
that.
word, not one that's used to.
I think I couldn't totally hear because there was a bunch of talking going on, but I think what you're looking for is for it to be like not parallel language.
Yeah.
Yes.
I use different terms intentionally because I know you have to be a resident to be it. So what you're saying, can you just repeat that?
Yeah,
'Cause
no,
I think
I'm
you
saying
have
it needs to be both. I think it just needs to be both.
Yeah.
So the second one, I think, needs to say, to be qualified for election to a school voting zone office of the board, the candidate must be a registered voter of the district and domiciled in the school voting zone. Because, but the registered voter qualification should be required for
I
both
think that's
zone
great.
and at
That's the
large.
fix. Okay.
Good,
I
good.
think,
I like it.
also, Kate, that, I think you got it right, because if you can't be a registered voter unless you're domiciled in the community.
Correct.
Once you're a registered voter, domicile is irrelevant.
Yep.
But for a school voting board, maybe use the term resident.
Or reside.
It doesn't matter, domicile is okay.
Okay, let it be.
I mean,
But I-
but that was my,
I think that's the right fix. It makes
Mine
it
or
crystal
Kate's?
clear. No, Kate, it's not yours. I'm just kidding.
Sorry.
No,
Good.
but I was very, very specific about not using the word resident, not using the word taxpayer. You have to be a registered voter to be a candidate for office in New Hampshire. So I think that's the fix and it works.
Good.
And then so Bill properly got this one fixed by pointing out, and Kate brought it home. So back to the second sentence is the thing that says, if you're in a voting zone, you're elected from a voting zone, and you don't move out of town, city, but you move, the district, but you move to another voting zone, you stay in that office until the next election, when the voters will elect a replacement for that. And I think that's what we
That's,
agree.
So-
I think that's good.
That is the language we talked about 2 meetings ago about that last phrase.
yeah,
And
on
that
the,
was the
on the,
discussion.
on the strunk and white, omit needless words. Do you need that last clause at all until the next election, period?
You have to define when they stop.
No, because then you have the question about, well, when the person gets elected at the next election, what's their term? Is it 3 years or 1 year? And you've lived this.
Well, I just, I mean, look.
So you've got to be expressive about
Clear.
it.
Let's just make things as clear
I think
as possible.
unnecessary words in a charter document are a problem, but until the next election means that they do not serve beyond the next election.
Exactly.
Period.
In
But then
that-
the question is, when you
No, it
have the
answers-
next
In
election.
that
It
zone.
answers when their term ends, but it doesn't answer how long the next term is.
Yeah.
So that's why you want, and that's right out of the election statute.
I give up.
No, I've seen that and wondered the same thing, but it's in the election statutes where it has that appointment language. So I think it's better to just put it in there and be safe.
So, just to be clear, because we talked about this last week, and
Ad nauseam.
and
Quite a bit.
I don't
Ad
want
nauseum and in 42 different modes.
a quick, clear answer will be very helpful. So, a person elected in their first year of 3, they move in that first year, and at the end of that first year, that's as far as they can go. That there's an election at the end of that first year, and they're out. They cannot go 2 more years. They cannot serve 3 years, which would be their official end of their term.
Right.
Is that correct?
Yes.
Correct.
Not
And
only
that's
is-
by legislature?
No, that's
by
by our
us.
charter.
That's by the charter.
Okay.
But-
So when you say they move, you mean they move within Concord but to another zone?
Yep.
They under this current language, they continue to be on the board for the remainder of that first year until the next election, where they're gone, their office is vacated, and there's an election for a new person to fill that spot for the remaining 2 years of that 3-year term. That person gets elected. It's a 2-year term.
And at the
Correct.
same time, the person who gave up that job is free to run again
Yeah.
if he or she meets the qualifications in a different zone. And it doesn't matter whether it's an at-large year or a zone voting year. The person will have every right to run again, so they have almost continuous. That goes to the issue of why make it so that some marginalized groups might be able to get people on the school board, have the school board look a little more like the city. But then we don't just unceremoniously boot them out the minute they move. When the moving van goes away, that's when you stop. No, we don't do that. So it goes through that year. Then the person who assumedly has had some experience, knows how to campaign, if they want to, can campaign again in their new location.
Tom, I think an easy way to think about this is take the concept of years out of it.
Well, the problem is
Years are irrelevant. You get elected from a zone, you move out of that zone, you're done at the next election.
I totally get it. I was questioning whether or not the answer we got was substantiated by law or by the
So,
charter.
no,
as-
so let me restate. Tom's question, and I heard him say it, is does state law
Yeah, I want to know that.
mandate that the person who's elected for a 3-year term in a zone, who moves from another zone to another zone, does it mandate that they could not remain a member of the board
Are we doing this
for the
again?
3 years?
Are we really
No.
doing this? with-
No, Tom is asking a question.
But I had asked this question last week.
And the
I
answer that
think
we
it was-
heard
Yeah,
was
I-
state law prohibited it.
Right.
Right, I heard
I think you
that.
couldn't
That's what I
have a
heard.
whole, I think it was if your charter says they cease, that they vacate, you can't have a holdover person or an appointed person
Right, that's the issue
for
we're
longer than
discussing.
till the next election.
Okay.
I think that's what Jim
No
advised
other
us
school
of.
district in the state is dumb enough to have a ward zone system. So,
Oh, really?
I'm being facetious, but I'm just thinking, it's obvious that state law wouldn't require it, because it's our charter that has that provision in it, and we can do what we want to with that particular provision.
I think the issue that we were focused on there was, I think 2 meetings ago, Jim told us that if we said that person had resigned the minute they moved, when the moving truck pulls up, they're out. If we said that was the fact, and then the chair of the board appoints somebody new, that person can't fill 2 years.
Okay,
I
it
think
has to go
Jim
to
told
the
us
next-
that person,
take-
that replacement person who was not
Okay.
elected could not serve more than until the next election.
So, at risk of bringing up bad laundry here, way back when you talked, Betty Hoadley, about, your example was someone was on the board 7 or so years, they moved out of their zone, they had 3 years left, they had tremendous wisdom, they were on various committees, heads of various committees, and now they leave this zone and they're done at the end of their term, done at the end of a term, 1 year,
Well, done until the next election.
okay, and they can't finish out that 2 years. And what a waste. So I understood it to say that it was state law that said that we couldn't do that, but it's our charter that says we can't do that. So why are we why would we allow that? Why wouldn't we allow that wisdom and that, I'm bringing up, again, admittedly.
I'd say for all the reasons that we discussed last week, but we're not depriving that person of their right to be on the board. They can just run from another zone, and if they're that good, they'll get elected.
Mhm.
Because I think what Bill is saying is that what we discussed is that it's contrary to having the zone system in the first place. I think the
Oh,
point
I
he
get
made
it.
last time was
The
that
compromise, Tom, I think it was a compromise, and it was sort of Eric's compromise. It was, they're done, they're gone right that minute, the minute the moving truck pulls up, as people have said. Or they get to finish out, they get to go to the next election.
and they could run.
And this is, Jim stepped in here, but the next election so help me here, because I'm trying to figure out. Are they done the day of that election, or do they stay on until the end of their,
Well, there'll be a gap
Original
between
term.
when they take office, if they win from the place to which they moved. This whole thing, I just can't even talk about it.
Hold on, so I think they're done when the other person takes office. So when
Okay,
the other person has the title of office, once they're elected, they take the oath, they're qualified. By operation of that, the other person is gone, they're done.
but they're not, they don't take that oath until the beginning of the next year?
Lyndon has an interest in this, she spoke of it the other day, and she may have something to add.
I need to point out to you that you don't have ward zone elections every year.
Right.
Right.
So if someone is in, and I'm sorry, I wasn't here last week, maybe you covered this. But if someone is in Zone A and they move to Zone B, then there would be an election that November for the remaining 2 years of that person's term. But the person who moved cannot run if it's an at-large election
Right.
that fall. So did you talk about
Well,
that?
they could run.
They could run at
They could run at large.
They could run at large.
Yeah, so they can always run, there's either an at-large or a district
They can
that they
always
could,
run.
or,
Yeah,
yeah.
no,
okay.
they
There's
can
always
vote
one
no
choice.
matter which year, no matter which form of election it is that year, it doesn't matter.
Okay,
They live somewhere
Right.
at large, and they live there, that place,
okay.
so they run from that place.
All right, sorry to bring it up if you
No,
already
it's
talked
good.
about it last week.
would be just a special election if need be.
This only proves the point that it's hard to be logical with an illogical system.
I think Bill kind of made that point too. So with only those language changes,
Hold on.
oh, go ahead.
I just want to make sure there's nothing else. Hold on. I just want to be thorough for Bill.
Please.
We talked, Bill, about the language in, hold on.
5, the last sentence, where we put in a colon and a semicolon.
Hold on. Wait, where is that?
That's in section 5 on page 3.
Do you understand the difference in the need for one? After a colon comes an explanation. After a semicolon comes something that's related, but wants to be differentiated.
And I did
That's
that.
fine.
Okay,
Exactly.
Yeah.
that's okay. I
That was
taught
the only-
economics, not English.
That was the only other language
The
that. got
political
clarified.
campaign stuff, that's right.
And I didn't think that was, plus Kate's making fun of me for semicolons, so I don't. I think, here's what I recommend. This document, right here, should be something that you should take home with you this week. And you should look through it one last time and make sure it does the trick. If you would like a fully clean version of this, I have it, and I can send it to everyone by email.
I think you should do that.
I will do that.
But-
Oh, okay.
And then, the only other new document you have, if we could turn to this for a
Yeah.
moment. These are the.
Before we turn to that,
Okay.
What's it say on the top?
so I think this last sentence is pretty complicated.
Do you have the new version?
Paragraph 5, well, let me go back, let me look at this version then.
Because that was where we made a simple correction to clarify. So it's like state law.
Well, first of all, what is any committee?
So maybe I can walk through this because I did it.
But, so you've added this, my initial issue on this one is, so when are these reports supposed to be submitted? And are we just leaving that to the school board?
To the board.
Okay. Because it felt like a royal pain in the neck to do it before, or right after you sign up, in the middle of the campaign, and then at the end, right? It should be, well, that's fine. If that's the way you want to leave it. But it has to be a contribution that is made for the purpose of influencing a nomination or election. So is that an out for people to say, well, I gave them money, but it wasn't for that purpose?
No, I think,
You're gonna
Bill
have
has
a
a law
barbecue.
partner that has been known to
They were
give
gonna have
money
a
to both
barbecue.
candidates, just to get them to stop calling.
Our clients ask us to do that, right? I end up giving money to people I don't want to see elected, but, right?
the reporting here
Good
will.
morning.
Thank God we don't elect judges, that's all I can say.
The bottom line here is, the reporting will not be of the person who's making the contribution. It will be by the candidate or by the political
Dark money,
committee.
this is dark money.
It'll be by the candidate or by the political committee. And whatever rules the school board thinks is appropriate, it'll apply to candidates running for school board, it'll apply to candidates running for charter commission, and the little Roman 2 there, after the semicolon, Ms. Hoadley, it'll apply to any group of people who are seeking to raise money to influence a ballot question, like, should we amend the Constitution? This issue affected my wife. And so it covers, the board is going to pass appropriate regulations based on them doing the work for what the candidates and people should do. And that's exactly what state law does right now. State law says, for candidates who are running for office and political committees that is more than one person coming together to try and influence a ballot question.
Now that I understand it, I don't know why the Concord City Charter, School Board Charter should contain that language, or why the school board has any business regulating what political action committees do. It just feels to me like if state law wants to do it, that's one thing.
State law does not do it for local elections like the school board. So right now, Bill, if we put a constitutional amendment question on the ballot, and a group of people say, I want to raise $100,000 to oppose this amendment, there is zero reporting for that under current law.
I just feel like it's out of our lane, but.
That's a fair question.
Nothing.
You wanna go to the mat on it?
Who does this for the city clerk?
The city has a provision that is very much like this in their charter, covering all elections and political questions.
Well, I think, given the climate that we live in, there has to be some kind of campaign reporting. I mean, hundreds of $1,000s were just spent in Denver on school board elections to get
Correct.
people in. And we need to be able to follow the money and know who's coming in, because right now, I mean, I could give someone, not that I had $100,000 to give, but I could hand someone $100,000 to run and no one would ever know I did it.
Well, in some
Or that they
respects,
got it.
yeah, sorry, Tracy, I interrupted
Yeah.
you. In some respects, by resolution, regulate the reporting. I think the board could say if they wanted to, don't tell us just how much you got, tell us who gave it to you.
I would
I hope
expect
so.
that they will, and that's what we did when we ran for charter commission.
But,
Can
yeah,
I,
so you know, nobody gave me money and I didn't ask for it.
would it be better if it was just simplified to say shall by resolution, require the reporting of any, political, or what, any contributions to any political campaign or ballot question, just like
Well,
you
here-
said, right?
here's
Just to
a-
keep it really simple and let the,
Jim, there's another way to do that, which is, and then this goes back to my omit needless words. I'm not sure you really need the second clause, because it really, well, the school board can decide what they want to regulate. And it says, reporting of political campaign contributions and expenditures made by or to anyone, so, any candidate. So if you've got a political action committee that's giving, the school board could decide, we want to know who the members of that political action committee are.
Unless the entire school board gets elected by that political action committee, then votes to not do that anymore. And you run the risk of that. I mean, I guess on something like this, with the way the world is going, I'd rather be more careful than less.
You are really paranoid
Yeah.
about the way the world is going, I
Well,
must say.
but unfortunately,
Yeah.
we're seeing it, so.
I mean,
well.
Look, I
I
am,
am a second grader, I don't want him in a
I'm
school
not
that's
gonna,
banning.
I'm
Yeah.
not, I'm not gonna die on this hill over this, but it feels to me like we're getting out of our, out of the zone and we should be regulating. But
Well, so that, I just want to say, of all of our amendments, this is the one that I may feel personally the most strong about. I think it is a big hole if we don't speak strongly in favor of transparency in election financing, because the question came up this last school board election. There were questions rattling around the neighborhoods about just where did all those signs come from. And I'm telling you, the where we're going in the world, this is important for, I believe, this charter commission to speak on. We spoke the last time, Bill, where there was no requirement for reporting for charter commission people running for charter, and we said, let's do it. But we didn't do it for school board. And in the 10 years since then, the school board didn't get around to it. And I think we should say it. And I think some of the testimony we've heard, including from school board members, has been, yes, this should be the same.
Right.
So I really feel strongly about this bill. I think this is something that we should do.
So here's what you could give me comfort on. Give me the language from the city council that has this same language.
That's what we
I'll
use,
get it.
that's what we used to get here. I can remember the stuff from Roger
Well,
Phillips.
Look, if people want to vote on it tonight, I'll vote in favor of it. It just feels to me like this could get challenged, but
Do-
that's okay.
So, all right, let me ask this question in a British accent. Shall I read the provision?
No.
No, it has exact similar language in the city.
Go ahead.
But it still does, this does not negate the greater population deciding the answer. I mean,
Correct.
this is our leadership
Yeah.
bringing
Right.
forth.
All of this stuff.
Right, exactly. I
We
mean,
might decide everything we've done over the last 3 months is a total waste of time.
but
Exactly.
but I do agree that.
They'll vote for this one.
Do we have the luxury of one more meeting that we could, you could give us some clear and simple language on just this issue?
Yeah, so that's what I was thinking. So is there consensus that you want language that requires the board by resolution to adopt a reporting requirement for financial contributions?
Oh, yes.
Yes.
So as long as that's a consensus, we'll clean it up. I mean,
Okay,
I
that's
think
a-
it can be very simplified. We'll look at the charter, we'll look at, there's a lot of electioneering statutes we can look at, and keep it really simple.
Okay.
Yeah, so for all of my complaining about complexity and all of that and how long this has gone on, you and Bill did a fantastic job here. You made it easy to follow. You honed down the issues that we had addressed into
Yeah.
language that we could understand. I really appreciate it.
Yeah.
So Bill,
Agreed.
all my teasing aside,
Kudos.
really good, and Jim, thank you.
It comes from all of us. Well,
So
I
the
s-
last document
Okay.
of this three, and you
Okay.
let me start. The last document that's before you to take home is one you haven't seen. This is the next step for the preliminary report that we're moving towards on a timeline that Jim is prepared to talk about tonight.
what's it say on the top line?
It says draft amendment questions
Got it.
in preliminary report.
And we don't have a copy of it.
Yes, you
we
do.
do.
Oh, we do, okay, yeah,
Draft.
sorry.
So, Bill, can I ask one other question, which is, when do we expect to hear from the AG's office?
I was engaged with him today a little bit, but we're gonna have a meeting this week on the appointment.
Okay.
But, so this document, just to give you a heads up and you'll read it, this is the first shot at what it actually would look like in the preliminary report. What you're supposed to do, under state law, is have this general question on the ballot, and then you list Amendment 1, Amendment 2, Amendment 3, Amendment 4, Amendment 5. And this was my first shot at, and I take full responsibility for making a mistake, at drafting an explanation for these 5 questions. And I think the next meeting, you should have taken a look at this and have thoughts about it, because we really have to get that's the last piece of the preliminary report process. So thanks,
Okay.
that's it for
Okay,
this.
well, folks, if you happen to bring your nice calendar that Lyndon gave us quite a while ago, that would be very helpful. If you don't, open up your phone to your calendar. And Jim, I'm gonna ask you to check me as I go along. What I did was took your information. Is that all right?
It's great.
I
Love
thought
it.
so too.
I love it.
Well, I've already done this work. Okay, so we're here at the 22nd of March, and I just checked it off because in 15 minutes we'll be driving home. The next date, the 28th of March, the date by which two public hearings should be noticed. Is that correct?
Yeah.
Okay,
I'll just note that so it,
28th of March.
you have to have under statute 2 public hearings prior to issuing the preliminary report. You probably already complied with those provisions because every meeting has had a public comment. It's been open to the public. But just to cross our T's and dot our I's, we ought to be
have capital PH.
public hearing, right?
Right.
So it's a big deal. It's a legislative
Okay.
public hearing, and the notice in the law does require that you put it in the Monitor.
Yeah,
and
I'm gonna get
those,
to that.
Those are very specific. So I just put that right from the law right in there.
On the 29th, enjoy your Tuesday at home, because I think we're still okay with that.
What happened on the 28th? I'm sorry, Dave.
The 28th,
That's just.
we don't have to do anything, that's, okay. This is reminders in general. Okay, after March comes April showers. On the 5th, I have regular meeting and first public hearing, capital P, capital H. On the 12th of April, I have the second public hearing, capital P, capital H. A regular meeting as well, and review and sign the document. On the 21st of.
I've got a question. Do you want to just go or do you want to stop?
No, go ahead.
Not me, but I know. I'll just point out that that's sort of trying to expedite the timeline so that we're not really up against the real deadline is the 21st of April. And so the 12th is earlier than that, but we don't have a meeting in between the 12th and the 21st. So we're hoping, since we're kind of there, that we'll have everything and we can meet on the 12th and get it all done and get the signatures on the preliminary report done. And that'll allow us to move the whole timeline forward a little bit too and give us a little breathing
bit of
room
room.
in May. in
Okay.
June.
So we're saying on Thursday, the 21st, be done, report due. On Friday, the 29th, the clerk makes sure that he has filed the preliminary report. After April comes May. On the 10th, we have a regular meeting, and the first, and I called it in quotes, after, meaning after submission, public hearing, capital P, capital H. On Thursday, the 12th, the Attorney General, the Secretary of State, and the Commissioner from DRA are supposed to have provided us notice of the receipt of the preliminary hearing. On the 26th, this is Betty being rude. It says, second public hearing, and in capital letters, why? And your comment was, we're only required to do one, and, but the law allows for more than one. And so, does anyone want to have a second public hearing after submission of the
I
report?
don't think we need it.
It could
Thank
be
you very
important for
much.
Mr. Russell to
Should we check with them?
Okay, you can see where I stand on that.
I know it feels good to just cross stuff off, so I put it on there so you could cross it off. Just, no.
It'll take more than crossing it off to make me feel really good. Okay, and now we're moving to the wonderful month of June. All strong, diligent, obnoxious women were born in that month. I happen to be one of them. And so on the 13th, we have the deadline for the state to respond. And on the 20th of June, the deadline for the final report. And in the margin, I have put 10-day turnaround, exclamation point, exclamation point, exclamation point.
So I'll respond.
Is that enough?
That's great.
We don't have any choice.
No, so all of the dates there's a bunch of the dates here. A lot of them cue off of the 4/21 deadline. So if we actually get the report done on the 12th, which is our goal, I think we just should do it. Then all of those dates,
Will
note of the
change.
public hearing, submitting it to the DRA's response, those all move up by however many days, 9 days.
We'll worry about that when it happens,
But it moves
but
up.
thank you.
But it'll move up 9 days. So the deadline, assuming we get it to the Secretary of State on the 13th or the 14th, that'll change that deadline. So those will all move up. So we'll have a bigger window between when we hear back from the state and when we have to.
Uh-huh,
when we have to
okay,
finalize
that
our
makes me
report.
feel better.
Yeah.
Lyndon, if you could, a suggestion, if you could just send an email to everybody on the commission with all of those dates, then in my case, I'll just get my assistant to put those on my calendar. It'll be a lot easier, right? But everybody then will have, instead of trying to write
Yeah.
it down tonight.
Well, I chose to go through it tonight
Yeah, that's
for
fine.
two reasons. First of all, just to confirm what we already have, and also to challenge Jim that I included all the parts, and also let him make me happy to be able to cross them off.
Yeah.
And I think we've accomplished both, have we not? And so,
I'm yet to do that.
I have a copy of this document that it's the timeline. If you're looking for another document to put in
Oh,
your files.
sure.
Do you want me to pass them around?
I want another document.
Well, if you have enough for everybody tonight?
I do.
Yeah,
I brought
send it around.
many copies, so I'll pass it
yeah,
to our chair first.
You live for this, huh, Bill?
May I ask who the author of this document is?
Charlie Russell.
Okay, thank you.
It's not bad, I mean,
It,
he wants the active
it
voice
felt,
rather than.
it felt Charlie Russell-ish.
oh, well, that didn't have a name on it, I put it, well,
Well,
Another helpful document, Jim.
so, at this point, I'll move to what's not on the agenda, and it basically is comments about tonight, or what's going to happen, questions, whatever. Go ahead.
Are any of these documents needed to be put on our website?
Oh,
They all should be, I think.
Every single one of these
No, no, I
documents
think-
No, no,
that
no,
you've
let's
handed
get-
out?
A red line version and a clean version of the document you passed around. I think your PowerPoint's really good. We don't wanna put the draft resolutions yet, they were not there yet. And the timeline, I think, so it's
So
really
you'll
just,
send me something?
it's just
will.
four
Thank
four
you.
documents,
Okay.
four documents.
okay, that's,
Thank you.
I just want to, you all set on which ones?
I'm
No,
gonna
Whatever
I'm
he,
gonna- I'm
whatever
gonna-
he sends
Oh,
me.
oh, all right, yeah, because we didn't want to, we
Said
didn't
Jim
want,
has-
I'm sorry, but just one thing, we didn't want to be premature and put things out until they were in
Yes.
final form. We, of course, want to be as open and transparent as possible, but on the other hand, we don't want to put out something that isn't quite ready. It's like the brownies, they need to be cooked. Sir?
See, town clerk's gotta
Given the
figure it out, start to get
timeline
his
we're
papers
on,
together.
I think it makes sense to get a consensus from everybody on, I mean, we just put the 12th in there to say, look, let's do it. I want to make sure we're all on that same page, because I'll actually tweak all the deadlines in here based on that. So if we finish it on the 12th, I mean, we can talk about the process, but how quickly will the turnaround be for then filing it and getting it out to everybody? A couple of days. So I'll set a manageable timeline. I'll revise this and then
So
send
if
it
it's
out.
done on the
Great.
12th, you send it to us and we have a few days to review it, or what?
No, we're gonna
you'll-
try and have it for the 5th.
Okay, good.
Yeah.
Good.
Yeah, we're
I'm not
signing
gonna be
it.
here on the 12th, so I just,
Oh, and I'm not either.
need my vote.
Uh-oh.
I've already
Well, we need
won, Clint.
We need your signature.
We need your signatures.
It will be ready in the morning, I can come in and do it before
Yeah, I can
leave.
sign it before I go. I don't leave until.
How long are you coming back shortly thereafter?
I'll be
Go on
back
vacation
in 1 week.
This will be-
So you're leaving on the 12th?
Where?
I'm leaving on the
See,
12th,
that-
returning on the 19th.
All right, so we'll get it done before, and we'll have to figure that out.
Yeah, let us figure that out, that's good. It'd be nice to get it figured out
Yeah.
so that we can do it by the 12th.
Right, so we have two people who won't be here on the 12th.
Suffice it to
Anyone
say that
else?
I
Everyone
will
else
be
will be here
instructed to
I'll be here.
Before the 12th.
I'm with Eric. I don't have any lights either.
I'll try not to get drowned in the Mississippi.
Haven't had a life in years.
They all live in Concord.
Damn it.
You got the 7 bucks.
I like being the contrarian. I excel at it.
Bruce and Susan bought it, please.
Are there any last-minute comments, questions, clarifications that we can handle tonight? Again, I have to say, everybody worked hard. The people who got all this ready worked hard.
Thank you so much.
And I think that and thank you both Bill and Jim. And then,
Jim is doing a fantastic job. I'm very
oh,
happy.
don't praise him too much.
Let him talk instead
It
of
might,
that'd be great.
it might go to his head.
Exactly right.
I will entertain a motion to adjourn by Bill in about 14 seconds. Those in favor say
Aye.
Aye.
Thank you. Good job.
That was a while.
That was good to get.
Honestly, I missed